All right, good morning. I'm going to call the docket. When I call your name, please say present or here. Tiffany Ann Rankin. Thank you, sir. Are y'all still working on the paperwork?
Yes, sir.
Okay. Landon J. Watson. Aaron Blevins. I see that the states filed a motion to withdraw. Do we have the extension paperwork on that?
We have an agreement we would like to put on the record, and then our solution was to have to sign that commissioner probation at his first appearance. I believe probation is going to have that state. We don't have it yet.
Okay. All right, and Joshua Gamble. I'm going to go ahead and bring in Mr. Wood and Mr. Blevins. Attempt here anyway. That's my witness. All right, good morning, Mr. Blevins. I'm going to ask you to unmute your device. If you'll just click that button.
Okay.
Good morning, sir. Can you see and hear me okay?
Yes, sir, I can.
All right, I'm just trying to get your attorney logged in. Just one moment here.
Okay.
That's okay for now, but whenever he leaves, it's gonna pin me. Yeah, if you'll change it, sure.
All right, good morning, Mr. Wood.
Morning, Judge.
All right, so this, I've called the morning's docket, and I noted that you and your client were going to be appearing via Zoom today. This is cause number CR 16-8, State versus Aaron Joseph Blevins, hearing on motion for vote. Ms. Heisel has made a brief announcement this morning. I'm going to ask you to do that again, Ms. Heisel.
Yes, Your Honor. Your Honor, Mr. Wood and I have come to an agreement to a 2-year extension of Mr. Blevins' probation. The allegations in the state motion were primarily financial, and he has provided me some information that we believe a 2-year extension would allow Mr. Blevins to complete his probation. So we are going to ask for a 2-year extension from the court. Mr. Blevins has had family members test positive for COVID, so out of abundance of caution, it's the state's recommendation that we do this on the record today, and then Mr. Blevins just sign those conditions at his next community supervision appointment. I've been assured that he's been reporting as he's supposed to. They have no concerns about that.
Did you hear that, Mr. Wood?
I did, Your Honor, and that's Ms. Hazel and I have discussed this case on several different occasions, and again this morning, and that is my understanding as well. And I've also conveyed that message to Mr. Blevins as well.
Okay. All right, then upon the state's tendering of the motion to withdraw the state's motion to revoke and terminate community supervision with the intention being to extend Mr. Blevins. Mr. Blevins, I want you to raise your right hand. I'm going to place you under oath. Mr. Blevins, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you put your hand down. So, Mr. Blevins, do you understand the agreement that you've reached with the state of Texas regarding your motion?
Yes, sir, I do.
And you understand that the state is asking, and I guess you're in agreement with having your community supervision extended for 2 years?
Yes, sir.
Okay. And has anyone threatened, forced, or pressured you to make you feel like you had to extend your community supervision?
No, sir.
All right. So this is something you're doing of your own free will. Is that correct?
That is correct.
Okay, and you understand that this is one motion that's been filed and is going to be resolved, but you understand the court doesn't want to have any more motions to revoke filed in your case. You understand
I
that?
understand. Yes, sir.
Okay. So you need to follow the advice of the counsel that I know that Mr. Wood has given you. You understand?
Yes, sir.
All right, so the court's going to approve the 2-year extension of the community supervision for Aaron Joseph Blevins. And Mr. Blevins, you'll need to sign that paperwork on your next reporting visit to the Van Zandt County Probation Department. Do you understand?
Yes, sir.
All right, the court is signing the order granting the state's motion on this day. Mr. Blevins, you're free to go and stay in contact with your probation officer so you'll know when the next time to report is.
Yes, sir. Thank you.
You're welcome. Thank you, Mr. Wood.
Thank you, Judge. Good to see you.
Good to see you as well, sir.
All right.
Mr. Watson, you don't need to come up, stay where you're at. Mr. Platten indicated he will be appearing via Zoom today. And he's also indicated that he also has a hearing a Zoom hearing in Wood County. And so he's going to be appearing on that first. So we're going to go ahead and take up some other matters and then I'll recall your case at the appropriate time. Okay. So you're welcome to stay in the courtroom. You're also free to get out if you want to walk around, walk across the street, do those things. You're free to do that as well. I've noted that you've been present for the docket. Okay. And I believe that Mr. Simmons is still working on paperwork with Ms. Rankin. Ms. Abraham, will you just check on that?
She is here.
Well, yeah, I understand she's here. I just want to see how close she is to being finished. If she's close, then we can go ahead and get that out of the way. And then we can turn it over to Judge Thomas. Okay. All right, at this time, I'm going to turn the bench over to Judge Thomas in CR 15-421 State versus Joshua Samuel Gamble.
Please be seated. All right, this court will formally call cause number CR 1500421, the state of Texas versus Joshua Samuel Gomez. Is the state ready to proceed?
Tony Curry, on behalf of the state, Your Honor, yes, we're ready to proceed.
All right.
On behalf of the defense, Mr. Gamble present. Judge, I'd like to put a few things on the record, maybe, Coach.
Yes.
Judge, I don't think you've ever met me before. My name is Shravanash Muralidhar. I'm going to give you a phonetic card, how to pronounce my name, but basically it's mural leader, okay?
I tried to get Judge Martin to help me, but he was not much help.
I know that it probably takes judges a few months.
All right.
So I just want to introduce myself, and this case has been pending for a while. And I think the state has requested a continuance before. I'm going to ask the court for a continuance today. The reason being is that at the 11th hour yesterday, Joshua Gamble's family called me and said that they can make a full payment on the restitution. And the person who called me and said that is a person in court today. It's his grandfather-in-law, Kevin Sheehan. And He showed me proof that he had gotten a personal loan for that and had deposited that into his bank account. I shared that information with the state, and what I'm proposing is a 1-week reset so that restitution is paid. My client has made small payments of $125, $200, but it's nowhere close to a lump sum payment as close as this. I've asked for no continuances before this, and I was ready to put on a full revocation hearing. I have all the witnesses I need to do that. I'm going to be calling 3 witnesses for the defense, and I'm going to be arguing on his behalf and introducing exhibits. I was all ready to do that prior to Mr. Sheehan's call to me at 4 p.m. yesterday, and that's when I contacted Ms. Curry and explained all this. So I know that the court is a visiting court, so it really depends on your schedule if you want.
All right, what is the state's position?
Your Honor, this man was placed on probation in 2017. He's had the opportunity to make payments since 2017, made none until June of this year, and since June of this year has paid, I believe, less than $500.
What is the total amount that we're talking about?
It's around $25,000.
Yes, Judge.
And
24,461.
All right, well, this court's position, and I'll just make you aware that I'm concerned about victims being compensated. And if I have to give him a week, he's only asking for a week continuance. I think it's worth it in my mind for the victims to receive complete and full restitution. And 1 week is not that much to ask. Now, Mr. Murlater, there's no agreement whatsoever. Is that correct?
That's
Both
correct.
sides. You understand that putting it off a week's not, I mean, y'all could still negotiate, but you understand that's not, there's no agreement. Does your client understand that as well?
Yes, Judge, and I've made it clear with my client and his family, and Ms. Curry has made that clear with me that there was no agreement.
All
In fact,
right.
there's been no plea offer in this entire
All right.
pending case.
I need to talk to, well, if the victim, I guess I might have been a prosecutor too long, but if the victims are compensated, I think that's a real positive thing. And I would put this off under those circumstances. I guess I need the coordinator to find out when.
October 14th.
October when?
14th.
All right. October the 14th, Counselor, Mr. Murlater, what is your situation that day? I guess we could do after, what is yours?
afternoon would be better for me, Judge.
All right, is that all right with you?
That's fine with me, Judge.
All right,
Hold on. 14th is fine, Your Honor.
all right.
Afternoon, right?
We're
Morning's
gonna,
fine.
that'd be at 1:30,
Okay.
or do you need it late? Do you need it later?
No, Judge, to accommodate the court's normal schedule, could we do 9 in the morning? 9 o'clock?
I'm fine with that, Your Honor.
Is that all right with you?
Yes, Your Honor.
All right, no, that's fine. 9 o'clock will work.
And Judge, I apologize, this was brought to my attention late yesterday. I would not be asking for this unless I knew that.
I understand that. All right. Based on the fact that that the defendant or his family is claiming they can pay the entire restitution amount, if we continue this matter today, this court is going to continue this matter till 9 a.m. October 14th. All right. Is there anything else that needs to be put on the record?
Judge, if you wouldn't mind swearing in my witnesses.
Sure, I'll be happy to. Have them approach the bar. If you'll just stay back there, please. All right, I need each of you to raise your right hand to take an oath. Do you and each of you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? All right. Now, I want you to state your name, please, starting on my left.
Dakota Gamble, Dakota Dakotah. That's just all.
All right. You have all been sworn in as witnesses in this matter. And because of that, you will have to be present on the 14th of October at 9 a.m. Ready to testify. Are there any questions? All right. Anything else?
No, Your Honor.
All right. This matter is continued and concluded today, continued till the 14th. Thank you all very much. No, I'm fine. That's a regular. Okay, but. Well, I'll see more portions, but. Press, where you want. You got to see, all right, and that's a negative relationship. All right. I think you just wrote exactly what it said. That'll be great. Thank you so much.
All right, court calls, cause number CR 20354, State of Texas versus Tiffany Ann Rankin. And Miss Rankin was set today for an evidentiary hearing. Is that correct?
That's correct, Your Honor.
And I believe, was it a motion to suppress?
That's right.
Okay. But I see here that there's an agreement that's been reached between the defendant and the state to resolve the case. Is that correct?
That's correct, Your Honor.
Looks like the proposed plea agreement is that to the charge of third-degree felony possession of controlled substance in penalty group 1 gram to 4 grams, that Ms. Rankin would be pleading guilty today to that charge. The state would be recommending the court convict her of that offense, sentence her to 5 years confinement in the Texas Department of Criminal Justice, but suspending that sentence and placing her on community supervision for 3 years with a fine of $2,000, restitution of $180 for Ms. Rankin to attend outpatient treatment as a condition of her community supervision. In addition, she would have a $35 reimbursement fee and $290 court costs. Mr. Simmons, is that the agreement that Ms. Rankin wants the court to approve today?
Yes, Your Honor.
All right, Ms. Rankin, if you will, raise your right hand, ma'am. I'm going to swear you in. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Your name is Tiffany Ann Rankin, is that right? And Ms. Rankin, are you a United States citizen?
Yes.
Do you read, write, and speak English?
Yes.
And have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Simmons, and you've also been represented by Ms. Barberi, is that right?
That's correct.
And are you pleased with the representation that they provided to you?
Yes.
Do you feel like you've had enough time to discuss your case with each of them and have all of your questions answered? Is there anything about this paperwork that you've read and signed today that you do not understand?
No.
Mr. Simmons, have you explained to Ms. Rankin her legal and constitutional rights?
I have, Your Honor.
Do you feel like she believes them and understands
Yes.
them?
She understands and understands the consequences. Yes,
And do you believe her to be competent today?
I do.
All right, Ms. Rankin, the range of punishment for a third-degree felony offense is confinement and TDC for not less than 2 years or 10 years, and a fine not to exceed $10,000. What that means is that this court or a jury, if they were going to hand down a sentence in this case, it would have to be somewhere within that range. I see here, based on your plea agreement, that a sentence of 5 years would fall within that legal range of punishment. Do you understand the full range of punishment in this case of 2 years to 10 years? And do you understand the plea agreement that I've read into the record today? You understand the plea agreement that you've entered into with the state wherein you're going to plead guilty and they're going to recommend that your sentence be set at 5 years prison time, but with that being suspended and you being placed on probation for 3 years. So you understand that if the court approves this today, you would be a convicted felon. You understand that the court would sentence you to 5 years imprisonment today. You understand that? You understand that the court would suspend that sentence. That means I would not make you go to prison today. I would put you on community supervision or probation. Do you understand that?
Yes.
And do you understand that while you're on probation, you're going to be obligated to follow terms and conditions?
Yes.
And that if you violate those terms and conditions, the state could file a motion to revoke your community supervision. They could bring you back to court. They could put on evidence. And if they prove to this court that you violated your community supervision conditions, the court would sentence you to 5 years. The 5-year sentence that you receive today, you would receive that if you violate your probation. Do you understand that? Understanding all of those things, do you want to go forward with the plea? Okay. And Ms. Rankin, then I'm going to ask you at this time, how do you plead to the third-degree felony of possession of controlled substance in penalty group 1 greater than or equal to 1 gram but less than 4 grams? And Ms. Rankin, are you pleading guilty because you are guilty of committing that offense?
Yes.
Has anyone threatened, forced, or pressured you to plead guilty? Court will accept the defendant's plea of guilt at this time. Mr. Simmons, any objection to states 1?
No objection, Your Honor.
All right, states 1, the stipulation of evidence is admitted and the court takes judicial notice of Ms. Rankin's judicial confession. Anything further from the state, from the defense?
No, Your Honor.
I'm gonna take just a moment and review the evidence. Is there a lab report with this evidence? I'm just gonna call this State's Exhibit 2. Thank you, Mr. Simmons. All right, based on the court's review of the evidence, and the court is going to admit State's Exhibit 2. Based on the court's review of the evidence, court finds that the evidence is sufficient to convict Ms. Rankin on this date. Court will follow the plea agreement. Court convicts her of third-degree felony offense, possession of controlled substance from the group 1. Court will assess her punishment at 5 years confinement in the Texas Department of Criminal Justice Institutional Division. Court will suspend that sentence today, place her on community supervision for 3 years. Court orders her to pay a $2,000 fine, $180 restitution, $290 court costs, $35 reimbursement fees. Court orders Ms. Rankin to attend outpatient treatment as a condition of her community supervision at the recommendation and direction of the Van Zandt County Community Supervision and Corrections Department. Ms. Rankin, have you ever been on probation before? Okay, did you successfully complete it? Or did you get revoked? Okay, was that a misdemeanor or felony? Misdemeanor, so you had to go to jail? Have you ever been on a felony probation before? So you understand that if you obviously understand what being on probation means. I understand, but you understand what the consequences are. So I've approved your agreement with the state today. So if you violate your probation and you come back and they prove it to me, then you know what your sentence is going to be, don't you? And that's going to be what? 5 years. Are you married? You have any kids? How many kids? 2. How old? 11 and 13. every age is important, but those two ages very, very pivotal right now to their forming their own identification in the world and understanding self-value and self-worth. And a lot of that, you know who that comes from? A lot of those things, you know who that comes from? Who? Their parents, you, mom, right? So not only do you have a chance to better your life, but you got a great opportunity for an 11 and a 13-year-old to make sure that they don't make the same mistakes that you've made. You wouldn't want this for your kids, would you? At all, right? So you get a chance to be an example. It's either going to be a positive example or a negative example. Either way, you're setting an example. So I hope that you think about that as you're on probation. Probation's not easy. It's not easy. Sometimes people have this myth that they think probation is just a slap on the wrist and no one's getting any justice for that. And probation is harder than going to jail and sitting in the cell and being told when to get up, when to use the bathroom, when to eat, when to go get exercise. That's like a child. That's what I tell my kids. I tell them when to get up. I tell them when to go to bed, as do you, right? Is it easier being a child or an adult? I would say a child, because they're being provided for, right? They're not having to make important decisions and keep roofs and overhead and foods in stomach, right? They're being provided for. Someone's doing that for them, right? Hopefully, right? So I think being in jail, like being a child, being on probation, like being an adult, you got responsibilities. Right? I'm telling you all this. I would rather lecture you now than have to lecture you later, because I'm not going to lecture you later. If you violate and you come in here, lecture's over. 5 years, good luck. Hope your kids are there when you get out. Understand? So I really want you to think about this. I know Mr. Simmons is probably giving you this speech, and Ms. Barberi, I'm sure that they've done this for you, but I really want you to understand that no one needs you in prison. We don't need you in prison. You don't want to be there, and your kids don't need you to be there. All right. So go over there and be a model probationer, do what you're supposed to do, get the government out of your life, and lead a productive life for you and your kids. All right. All right, Ms. Rankin, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted with the bailiff. And then after that, I want you to go with Officer Matura here from the probation department, and she'll give you further instructions.
Thanks, sir.
Jeff, is there no fingerprint right here in this drawer? Yeah, it should be right here for you. Sorry about that. I don't know if we told you that or not.
Yeah, that's.
Rachel, I'll leave this to y'all on probation program. But my only requirement is that you be involved in one of your vital license.
Mr. Watson? Okay. That's fine. Mr. Watson, come on up here. And we don't have to go on the record. So I haven't I haven't seen your attorney, Mr. Platten. He had indicated my coordinator that he was going to be doing a Zoom hearing in Wood County. I haven't seen him. He hasn't logged in. So have you had any contact with him? Did he give you any additional information? Okay. Has Mr. Platten ever made an appearance here in court with you? Do you know? Right, I'm talking about in here with you. Is that concerning to you? It's concerning to me as well. So,
Mr. Watson's been trying to get everybody downstairs like 3 months ago. He's never requested discovery. He informed me yesterday he didn't have this. Of course, this is not in this court, it's downstairs. So I was unaware. He brought it. He didn't mention to me yesterday that he was ill or would be unable to appear, so I brought it for him to have. But this has been pending for 3 or 4 months, and he's never gotten discovery. Let's be clear, Mr. Watson's MTR has 2 counts. One is the DWI, one is a technical. This is the MTR.
so this is what I'm gonna do. I'm gonna have to keep you here until he makes an appearance. Okay, but this is what I want you to do. I'm gonna drug test you today. So I'm just gonna send you over to the probation department. Yeah, go over to the building and I'm gonna tell Officer Matura and they'll know you're coming. I want you to go there and get a drug test and then just come back and we'll wait on Mr. Platten. Okay? Nah, that's okay. Now just go over there and get a drug test and then he'll zoom in at some point, and whenever you come back, if he's here, we'll do the hearing. If not, we'll just have to wait on it. Okay? All right. All right, court calls CR 18113, State versus Landon J. Watson. We're set on contested motion to revoke today. State, are you ready? Mr. Platten, are you ready?
We're not ready to proceed at this time. The state informed me that they're going to be sending a disc where a disc is available to be picked up of information that is subject to the revocation. They have also extended an offer to extend this probation term that he's on if he were to accept a guilty plea in his misdemeanor DWI. I informed the state that that may come, but I need to see the video first. And that's
I thought we addressed this at the last court setting. I think this is today's our 6th hearing on the motion to revoke. And I believe at the last one, we've
had a lot of
resets, 3 motions for continuance. I thought we've already addressed the whole underlying DWI video. That's the notes that I have. State, what do you have?
Judge, I believe that's the case. I was unaware that Mr. Platten had not had it. He did inform me yesterday. It's not. I brought it with me to court today. I was unaware Mr. Platten was going to be available. So I have the DVDs here. My office informed me that the replacement DVDs were going to be made. We don't have any per our office policy supply us discs, but beyond that, we have the copies. Because I was under the assumption that we would be providing them to them today. It was my understanding that we were going to get this resolved the last hearing, but I did not realize that it had not been requested or provided to Mr. Platt previously.
Well, what happened on July 28th? We talked about this. I mean, I think it was July 28th. I know at least on August 26th, I mean, more than 30 days. I mean, I keep resetting this, trying to give both parties an opportunity to get where we need to go.
I think this is the first time that the disc has actually been in hand. We keep coming back needing discovery and stuff, and we discussed this yesterday over text about, well, not say text, emails about how to resolve this case. I think we've got it resolved. I think in my diligence, all I need to do here is watch this video. That's it.
Well, I'm saying, how come that hasn't been done in the last 30 days?
I haven't had a video.
I know, but on August 26th, you said you didn't have a video.
And it wasn't available.
State, it wasn't available on August 26th?
Judge, my office received no request for the video. I told them to make a copy. It was made.
Mr. Platten, do you represent Mr. Watson on underlying DWI?
I do.
Okay, and so when have you had a hearing in the county court at law? I mean,
I think there's been an arraignment. That's just the level it's at.
when was that?
I don't know right now, Your Honor. I don't have that file in front of me.
State, do you know? What I'm trying to figure out is why are months and months going by and there's obviously important evidence that is needed to be reviewed and no one's asking for it, no one's picking it up, no one's reviewing it. And we just keep resetting. I'm trying to be patient here, but it's just, I mean, this is our 6th setting. And
I could go back and find emails that were sent a long time ago where I was requesting this information, but the state didn't have it. They didn't have it from DPS. First, it was blood stuff. And then it was, I was first on the revocation and then I got hired on a DWI. And that happened just here within the last month or so. And I've been requesting the discovery. I mean, I could find emails from who knows when. I just don't have them pulled up right now.
So there was no DWI video on the underlying misdemeanor case when it was filed?
Yes, sir.
There was? Mr. Platten says there wasn't.
We received the.
And pull that microphone closer. So I want to make sure he's able to hear you.
Let me see here.
Received the DWI in January. It was filed in August because we were awaiting the blood results, which we received in, it's like, it appears to be August. It was just filed 8/27. It appears it was set for, this is the DWI, not the felony. It was set for arraignments 8-2, so it can't, we scanned it in 8-27. Was set for arraignments 8-2, which was arraignment was waived, was set for a pretrial on 9/8. There was a motion for continuance that was granted and is set for pretrial 10-4.
So there was a hearing on 9/8 in the county court of law?
There was not, it was reset by a motion for continuance by the defense state. I don't know, I don't have all of that before me, I just have the documents.
So according to your records, when was the first time the DWI video has become available?
Beginning of September.
And I'm looking at a string of emails that go all the way back into June, Your Honor, where I've been talking about DWI discovery. And it's bounced from different individuals. Hillary first said that she wasn't handling it. That was Tyler's case. And they're trying to see if they can get something open on a portal or whatever. And so it's just bounced around. I'm not trying to drag this out, Judge.
I mean, today was set for contested hearing. And you contact the court at 4 o'clock yesterday and say that you're not going to be here. You see my concern? You say you're not coming. And you send me a doctor's letter. No motions for continuance, just doctor's letter. You're not going to be here.
Judge, I'm having a hard time with my vaccination. I'm having a hard time even with words.
I understand. I called your family nurse practitioner and I spoke with him. Because he said if I had questions to give him a call, so I did.
Well, did he address that?
He did. He was under the impression that you shouldn't be practicing law.
Well, thank you.
That's what he said.
Well, he gave me a month to get my stuff together, and there's courts that want me to take care of these things, and I'm doing what I need to do.
I understand, but I also understand, Mr. Platt, and you were in my court 12 days ago. 12 days ago, and there was no problem being here. There was no problem getting.
I had the vaccination last Wednesday night, the second vaccination. So it was after that.
Okay, well, those are things I need to know. There's no motion for continuance. It's just a doctor's letter saying to excuse you until October 28th. So I'm supposed to just reset all your cases to the 28th? I don't know. So I call him and I ask him what's the extent of the issues. And that's what he told me, that you can't form words. You're not thinking clearly. I said, does he need to be practicing law? And he said, no. That's what he provided me. And so that's
I didn't think that I could handle today's hearing. You know, there's times that I have a difficult time with words, things that I'm even typing are sometimes messed up. But if I focus enough, I can get my words out, and things are getting better. I'm not here to waste your time or mine. I'm here to represent my clients to the best of my ability. And if I couldn't do it, I wouldn't be here.
Well, you're not here. You're not here. I don't know that you ever made an appearance in Van Zandt County on this case.
Not physically, but I have appeared on Zoom many times.
Right, and I've done that for you. I've extended you that courtesy because I do worry about these things. I don't want you to think for a moment that I don't, but it just seems like things are not being handled and you're not showing up.
I know this.
Last minute, I don't get a continuance. I get a letter and we tell you, hey, we need to go forward the hearing, and you tell my coordinator, you're not coming.
I've got communications that the probation, we've got an agreement to extend this thing. I mean, I could take care of it right now, not look at discovery, not do my job, not be effective, but that's not what I'm doing. I want to look at the video to see if there's any issue with it.
How come you didn't pick it up 30 days ago?
I didn't even have notice that it was available that I'm aware of.
State, you agree with that? I don't see any communication between my office.
Did you ask for the video? Did you?
Judge, I'm looking at this stuff requests all the way back into June.
And I understand. I don't have that.
I'm looking, see, these are communications that you're not seeing. These are emails with Hillary, with.
Well, show it to me. Show it to me. Hit screen share and show me.
How do I do that? Screen share right here.
If they're not providing it to you, then.
Oh, do I just go to desktop one?
Yeah, try
Hit
that.
share,
Hit share and see.
open system.
Should just be at the bottom where it says share and it'll show you share screen.
Yeah, it went to some sort of security and privacy thing.
Try it again.
Okay, there's desktop one.
How many screens do you
And
have?
there's I've got a few to open. Do I need to close some windows?
I would probably close some just in case you don't want to share something inadvertently.
Okay. And my wife is in Canton right now. She can come by and pick up that video.
That'd be great, but I expected it to be picked up the last time y'all asked for a reset. That's what I was expecting. You asked for the time, I give you the time, and I've granted every request in this case, everyone, going back to April. Sure, and if Mr. Watson can be resolved, then by all means, let's get him resolved. Let's quit kicking the can down the road and delaying it. I'm sure.
Hold on, just close the email on accident.
Yes.
I just had them up and closing things. I only open systems preferences and find it again.
You'll have to open it up and then hit share. And then when you hit share, it'll let you pick what you want to share.
Yeah, there's something on there's a Zoom camera on my security and privacy here. Maybe I have to make a change just to allow this.
Mr. Woodwalk, while he's looking, do you have access to those emails, or is that Discovery?
I have an email from, and I believe Mr. Knoll was on this previously. The discovery was turned over to Mr. Knoll as well. And then I do have an email from Mr. Watson from 6/28 in which he asked if we can mail him the videos. And I referred him to my secretary to do that. And then that's all I have. And that was 6/28. So he did add, obviously Mr. Platin's defense, he did ask, can you mail them? I referred him to my office to perform that. Beyond that, I don't have access to anyone else's.
And that's what you say. You have, Mr. Platt, and you have an email to the staff asking for it to be mailed or make arrangements.
He may be reading something from Platt and Law 1-2. If he's reading something from Platt and Law 1-2, he's communicating from my assistant. If it's Platt and Law at Gmail, he's communicating with me.
He says he doesn't know.
I mean,
I'm saying, do you have an email to the staff, or do you have an email from your staff to their staff saying, hey, mail it, or here's the disc, provide a copy? I just want to see some due diligence on.
Because that would be from my assistant, because she said that they were trying to determine if they were going to mail it or what was going on. That was the last thing my assistant told me yesterday.
I just want to see the diligence, the due diligence on, are we trying to get this resolved? I don't want to keep resetting for 30 or 60 days and it keep being the same thing. Hey, I need to look at the disc, but I'm not coming to pick up the disc.
I can tell you my wife's in town. She'll come get it. If you want to see any communications, I can either email them or fax you what I have. I have nothing to hide here. And I want to get this resolved. The only thing I want to do properly is view the video and do what I should do is look at the discovery. And if anybody knows about me being thorough, y'all should know that I'm thorough. I just don't take my people in there and play them. So do I think
I'm not suggesting that you did. I'm just telling you this is the sixth setting.
I got you. Well, it takes a while to get here sometimes. We're dealing with DPS, distance, videos. We're dealing with assistants, multiple prosecutors. I don't know what else to tell you. I wish I just had it all here laid out in front of me, but I don't. Right now, all I have to do is see a video.
What do you want to do, State?
Judge, I believe we'd likely have an agreement. I don't think we necessarily need to reset it to the next contested docket. We can set it for plea if Mr. Watson and Mr. Platt are comfortable with that. 2 weeks, he can get his discs, review them, we can set it for a resolution, get all of those resolved. That's what I'm saying. His true interest is getting Mr. Watson off of his motion to adjudicate and back on probation, which is, I believe, what is in the interest of justice. In this case.
All right, I'm going to set this for a hearing on the motion to revoke on 10/14. I'm also going to set it for the contested docket on 10/28. So if we don't have a resolution on 10/14, then you're on notice that we're going to take up the hearing on 10/28. So Mr. Watson, if you'll come forward, I'm going to have you sign this notice of appearance. The sign right there on the X. I'm going to give you the yellow copy. Here's a pen. All right, you understand what we're doing? Okay, we'll be back on October 14th. Mr. Platt and Mr. Woodwhack are gonna try to get these videos exchanged, I guess, and figure out if they're gonna resolve the case. We'll be back on 10/14 with either a resolution, or you'll tell me that day that there is no resolution, and then we'll set the case for 10/28.
Yes, sir.
All right, you're free to go. All right, we'll be adjourned in this case.
Thanks, Judge. If you need to contact me, know myself.
That's okay. I'll see you on the 14th.
Yes, Judge.
All right, that's going to conclude this morning's docket. We will resume at 1:30, and I'm going to have the inmates brought over. You anticipate any contested hearings?
I believe Ms. Templeton may be contested as titles. There is ongoing discussions about Mr. Pharisee, but whether that's actually going to be heard or not. There's a plea on Mr. Mendez Gonzalez. I'm unaware about Mr. Osmond on that. Audrey Thompson,
Mr. Stevens is not going to be available, so we're just going to,
My understanding from the last hearing was Mr. Knoll was removed.
he was, and
We didn't know up until yesterday that Mr. Stevens was on the case, so we were unaware what the status of.
well, it went to Debbie Beasley. She was conflicted. Then it went to Casey Chester. She was
There are a
conflicted.
number of co-defendants in the case. I understand the difficulty in fighting it in the defense counsel. We appreciate this, Abraham, and I'm not saying that just because.
Yeah, so we're going to bring her over just to tell her that Mr. Stevens has contacted us today and said he's unavailable. He's got an issue at home, and
And then the state is totally fine with that. We're just unaware of the status, but we appreciate that.
so I'm probably going to set her again on pretrial. I'll just set her 10/14, and then we'll set both of them on 10/14 and come back in 2 weeks. But we're going to bring her over and tell her that.
And then we're gonna add that.
Curtis. And that's Mr. Knoll, right? Was it Kayla? Do you have that? You don't have the cost. Kayla Curtis, MTR. I'm gonna tell her, yes. I'm gonna tell her we're gonna reset her for 10/14 so Mr. Stevens can get here and. All right, so the court's gonna stand in recess until 1:30, and we will